On August 8th, 2025, a federal judge ordered the tractor industry's biggest companies to surrender their secret spreadsheets. Over 1 million lines of Excel data now expose hidden profits, rigged repair fees, and internal strategies never meant for public eyes. If the right to repair crisis was already fracturing U.S. farming, what will these revelations unleash? And just how far will the damage reach once everything comes out? The sun hadn't yet burned off the morning fog when the engine warning light flashed red. For one of the lead plaintiffs in the lawsuit, a fifth-generation farmer in western Illinois, this was the start of a harvest nightmare. The combine, less than 2 years old and still under warranty, refused to run. The display showed a single error code, but without the manufacturer's software, he couldn't even diagnose the problem, let alone fix it. He called the nearest authorized dealer, only to hear there was a backlog, 6 days before a technician could even come out. Every day, the combine sat idle. Hundreds of acres of soybeans stood vulnerable to rain and rot. The clock kept ticking. When the tech finally arrived, he plugged in a tablet, cleared the code in less than 15 minutes, and handed over an invoice. The charge was $1,200, just for the visit and a software reset. No parts were replaced, no repairs were made. The farmer's hands, stained with years of diesel and dirt, were tied by a password he'd never be allowed to know. He kept a copy of that invoice, like every other one from the past 2 years. Each one a reminder of lost days, mounting costs, and a system designed to keep him out. In those moments, it didn't matter that he owned the machine outright. Ownership meant nothing if he couldn't keep his own farm running. For farmers across the country, this wasn't a rare story. It was the new normal. And the documents locked away inside corporate servers held the answers to why. Promises of change swept through the industry in early 2023. John Deere and other leading manufacturers signed memoranda of understanding with the American Farm Bureau Federation, pledging to grant farmers some access to diagnostic tools and repair information. These agreements, announced in March 2023, were presented as a breakthrough, a way to ease tensions without government intervention. The memoranda covered about 3/4 of all agricultural equipment in the United States, including brands like Case IH and New Holland. Manufacturers promised that farmers could buy diagnostic tools directly and perform certain repairs on their own equipment. But the fine print told a different story. The memoranda left room for high subscription fees, limited software capabilities, and strict controls over what repairs were actually allowed. Even with these pledges, farmers found themselves paying $1,500 to $3,100 a year for access to tools like Service Advisor or CNH's electronic service tool. Most software remained locked behind dealer networks. Independent repair shops reported that, despite the agreements, they still faced roadblocks, missing files, incomplete instructions, or outright refusals from manufacturers to provide code-clearing capabilities. As frustration grew, lawmakers in Colorado took action. In 2023, the state passed the nation's first right-to-repair law for agricultural equipment, requiring manufacturers to provide the same diagnostic and repair tools to owners and independent shops. The Colorado statute became a rallying point for advocates, with at least 15 other states considering similar legislation by 2025. The industry's private promises had not been enough. Pressure mounted from both the courts and the public, pushing the fight for repair rights from boardrooms and trade groups into state houses and federal courtrooms. On August 8, 2025, a federal court order from Judge Ian D. Johnston sent shockwaves through the agricultural equipment industry. The ruling compelled AGCO, CNH Industrial, and Kubota to turn over what their lawyers called the crown jewels, the most closely guarded business data in their possession. This was not a handful of memos or a few financial reports. The order covered more than 1 million rows of Excel spreadsheets, each line tracking the precise markup on replacement parts, dealer profit margins, and internal communications about repair strategies. Judge Johnston explained his reasoning in plain terms. If the Federal Trade Commission could access these files to build its case, fairness demanded that John Deere and the 16 farmer plaintiffs should see them too. Anything less, he wrote, would put one side at a fundamental disadvantage. The breadth of the data was staggering. Pricing structures, dealer-level profitability, and private strategy emails were all laid bare under strict confidentiality rules. For the first time, the evidence that could explain why repair costs soared and why farmers faced so many barriers was no longer hidden behind corporate walls. The floodgates were open, and the secrets of an entire industry were now part of the official record. AGCO's legal team moved at breakneck speed, filing a rare emergency appeal just days after the court order landed. They warned of disaster, calling the forced disclosure of their confidential spreadsheets and internal emails a threat to the company's survival. In filings, AGCO described the data as their crown jewels, not just numbers, but the very formulas and strategies that set them apart from rivals. Their lawyers insisted that once this information left their control, no confidentiality agreement could truly protect it. They painted a picture of competitors poring over their most sensitive pricing, dealer profit margins, and sales tactics, with the risk of leaks or misuse hanging over every line of data. On September 24, 2025, Judge Johnston delivered a blunt answer. The appeal was denied. The court ruled that strict confidentiality rules were enough to guard against abuse. AGCO's fears of irreparable harm and competitive sabotage were not enough to outweigh the need for fairness in litigation. CNH Industrial and Kubota, who had joined the fight to keep their own data sealed, lost as well. The outcome left the industry exposed. Every line of code, every margin calculation, every strategy memo would now be open to scrutiny by John Deere and the farmer plaintiffs. The secrets that manufacturers had guarded for decades were finally in the hands of their fiercest critics. Service Advisor, Electronic Service Tool, Diagmaster. These are the digital keys that unlock a modern tractor's brain, and every major manufacturer keeps them tightly guarded. For a farmer, buying a $300,000 tractor or an $800,000 combine does not include the right to clear error codes or recalibrate a sensor. That power sits with the dealer, behind a paywall. John Deere charges $3,100 a year for its Service Advisor subscription. Case IH and New Holland owners pay $1,500 for the EST tool. Kubota's Diagmaster is required for even basic diagnostics. Without these tools, a simple software reset becomes an expensive service call. The software isn't optional. It is the only way to get a machine running after a fault. Farmers pay the price, both in downtime and in dollars, every time their equipment locks up. The system is less about technology and more about control. On January 26, 2026, USDA Deputy Secretary Stephen Vaden addressed a webinar of agricultural law experts. He made the agency's position unmistakable. Farmers have the right to repair their own equipment, and industry efforts to prevent that are illegal. The statement landed just days before the Environmental Protection Agency issued its own guidance. On February 3, 2026, EPA Administrator Lee Zeldin declared that manufacturers had misused the Clean Air Act to block access to diagnostic tools and repair software. From that point forward, the law no longer supported those restrictions. Farmers gained the ability to temporarily override emission systems for repairs, as long as their equipment returned to compliance. The Small Business Administration projected the impact could reach $48 billion in savings nationwide, or $33,000 for each major repair. For years, manufacturers had leaned on emissions rules as their main legal defense. Now, that shield had been stripped away. Inside the court-ordered files, investigators now hold more than 1 million lines of raw data, dealer margin spreadsheets, part-level pricing logs, and annual accounting reports from AGCO, CNH Industrial, and Kubota. These documents break down exactly how much profit is made on every replacement part, how repair service margins compare to new equipment sales, and which strategies were discussed in internal emails to keep repairs locked behind dealer networks. For the first time, farmers and independent technicians have a forensic roadmap, where to look for inflated markups, how to spot patterns in dealer profits, and what to show lawmakers and regulators as evidence. The FTC lawsuit against Deere presses forward, and this data arms farmers everywhere with the tools to challenge high costs, to back new state repair laws, and to document every denied repair or excessive invoice. The secrets are no longer hidden. Now it is a matter of what farmers and advocates do with the evidence in their hands. Today, the spreadsheets stay locked behind court orders, but the stakes are public. As farmers and regulators press for answers, the industry's secrets can no longer hide behind software. The real cost of repair is about to become everyone's business. What will accountability look like when the data is undeniable?